Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. On 29th of July 2022, the day before yesterday, two judges bench, Justice A.M. Kanvilkar and C.T. Ravikumar, while dealing with the case of Rohit Thamanna Gowda versus State of Karnataka in Civil Appeal number 4987 by 2022, right? While dealing with GWOP, we can say simply Guardian Wards Act, held that the desire or the wish of a child is different from best interest of the child. Desire of the child is on one side, whereas interest of the child is on other side. So Supreme Court showed edge towards the interest of the child only. The High Court tend towards the interest of the desire of the child. Supreme Court tended towards the interest of the child. So what is the difference? Now we'll discuss. Before discussing, let us go to the grassroots, that is facts of the case, right? So this Rohit Gowda is from Bangalore, Karnataka. So Gowda means you must, by now you would have known, he is from Karnataka. And he was staying in USA for the past 20 years or 30 years, 20 years he was in the USA. He was married in 2008. On 19/3/2008, his marriage was performed, with his wife. Then they shifted the family to Washington DC. Of course, for some time the family was happy. They lived a happy married life for some time, and as a result of their happy married life, so this woman gave birth to the son on 3/2/2011. That is Arya Ranjani Rohit. Arya Ranjani Rohit is a boy. Right? He was born in Washington DC. So since he was born in Washington DC, definitely we can call him as ABC, that is American born citizen. So he is almost an American. So now, of course, later some differences cropped up. Of course, conflicts and confrontation have become common between them. In the meanwhile, so they got in 2010 itself, they got the green card, PR and other things, everything is obtained. But what happened is, this man's, Gowda's mother, she was not feeling well. Therefore, he came to India on 3/3/2020 to see his ailing mother, or to attend on his ailing mother. He came to India. And incidentally, or without his knowledge, or without his consent, on 11/3/2020, this woman came back to India without his knowledge. And since he was already in India, he didn't know her whereabouts. Till he went back to USA, he didn't know her whereabouts. He searched for her. He filed a writ petition before the Honorable High Court of Karnataka, stating that his son's whereabouts are not known. When he was in USA, he has reported the matter to the Complaint Office of Children's Issues USA. So he filed a complaint there, he filed a writ petition here. All these things, he has followed the legal procedure. Ultimately, he came to know that the daughter, that his son is with his mother in India. Therefore, that High Court petition has been waived off, because the High Court called that mother and boy, and the boy stated that he is feeling happy, he will study in Bangalore, he wanted to stay his mother. Finished. So therefore, High Court allowed the desire of the child. Okay. But here, since he filed a complaint with the Children's Issues Department of USA, then what they have stated is, they have actually asked for returning of the boy from India to USA, because they wanted to, on 26/10/2020, after 9 months or so, the court held that, the Superior Court of Washington held that the person, the child should be in the custody of the father, because father is the legal guardian there. Even according to Guardian and Wards Act 1890, yes, father is the natural guardian, right? So on 9/3/2021, the United Nations Court, or the United States of America Court, so therefore they have sent a letter to the spouse, that is his wife, to send back the boy and also get a solid or maintenance, monthly maintenance of 5,000. So final order has been issued by the United Nations Superior Court. But what happened is, the point is here, High Court has already set aside this boy to stay along with his mother. Therefore, this man has approached the Honorable Supreme Court of India with a plea that in view of the US top court judgment, the custody should be handed over to him, number one. Number two, since he is an American citizen, his culture, his way of bringing up is totally different. Therefore, better shift him to USA. These two requests he has made before Honorable Supreme Court of India in the civil appeal. So please remember, here the important point to note is, High Court called the child and asked him with whom he wanted to stay. He said he will stay with his mother, he will study in the so-called Bangalore. Therefore, they have not allowed the writ petition. Ultimately, Supreme Court, now the findings of the Supreme Court, they are more important. It is paramount consideration of the welfare of the child or best interest of the child. So, when the couples are at loggerheads, when the couples are fighting with each other normally, and when they want to part way at Parthian shot, then they will try to depose or they will try to depict the others to be unworthy of custody. Wife says husband is totally unfit to take care of the child. Husband says wife is totally unfit to guard the boy. So normally they will be telling like that. So Supreme Court held that the child was born in USA. Then he has been brought up for about 7 years or 8 years in USA in the social and cultural value of the USA. So now the boy is accustomed to the lifestyle, the language, the customs, the rules and regulations of his native country, that is USA. He will have better prospects in USA. So therefore, in the best interest of child, the child should be sent back to USA, honoring the US court tradition also. 2 points have come in this one. No doubt, the desire of the child is to stay with his mother, but the interest of the child is better to send him back to USA. Since it is a Supreme Court order, definitely High Court also cannot do anything. And this woman has to send back the boy to USA. Very good judgment. So, the main point to consider is desire and interest. Desire of the boy as well as the interest of the child. Both of them, Supreme Court has actually taken decision in favor of the USA decision. Right? Very good judgment. Please read it and enrich your legal knowledge. Thank you very much.